The community property question from July of 2002 is not an easy question. It requires a lot of in-depth analysis. It also features a crooked, unethical lawyer, but it is not a PR question. Take a look with me at the call of the question. 1. What are Hank and Wanda's respective rights in the parcel of land and the sculpture? Discuss. All right, so there are two items of property we've got to talk about here. We will apply our basic format, source, actions, and presumptions. 2. Which of the property set forth in the facts can be reached to satisfy the obligations to pay child support and the attorney's fees? Discuss. Well, we've got to look at the facts carefully, but this is an issue that is tested regularly on California community property essays. And you've probably seen it before just in this seminar. But the quick bottom line is we will seek to satisfy the child support payments with separate property of the parent spouse, but community property assets are available as well if necessary. So please go to the top of the question, and here, right up front, it looks as if we are dealing with quasi-community property, and as it turns out, we will apply quasi-community property law principles. But what's going on here is we've got a crooked lawyer in Illinois who uses his knowledge of the law to defraud and lie to Wanda and make her believe that they are legally married when in fact they aren't. Then in paragraph 2, the couple move to California and become domiciled here. At this point, the money in Wanda's account totals $40,000. She spends this money to buy a parcel of land in Illinois, and she takes title in her name only. Right after they arrive in California, Wanda inherits an expensive sculpture. Well, inheritance equals separate property, right? Hank buys a marble pedestal for the apartment and told Wanda it was so we can display our sculpture. Well, he can use that language, but it's not going to give him an ownership interest in it. They both frequently refer to the sculpture as our collector's prize. And this issue also is virtually identical to similar issues that have been tested repeatedly. And I will not comment further. We will look down below and analyze accordingly. In paragraph 3, Hank is named the father of a 6-year-old child, and the mother files a paternity suit in California. The court determines the child is Hank's and orders him to pay $800 a month in child support. In January 2002, Wanda discovers that her purported marriage had never been valid, and Hank moves out. Hank hasn't paid the lawyer who defended him in the paternity case, and he hasn't paid child support after 3 months. He hasn't paid any after the first 3 months. So now we have to analyze the parcel of land, the sculpture, and the child support and attorney's fees. So actually, when you think about it, technically, there's 4 items that we need to deal with, but the child support issue is a fairly common issue, but it's being tested in a somewhat unconventional fashion. To my way of thinking, it's identical to the earlier incarnations of the issue. So now turn to the outline of issues, and let's see how we can put order to this big mess of facts. As is the case in a fair number of community property questions, we have to have some analysis about the relationship and the governing law up front. So the first section that you will see in my outline of issues is dealing with Hank and Wanda's relationship. I first lead with the fraud committed by Hank. I indicate the relationship started out being domiciled in a non-community property state, Illinois, and in 2000 they moved to California, a community property state. Then the conclusions, I stop Hank from profiting from his fraud. I consider it a quasi-community property relationship. A non-California marriage domiciled in California. Next, we focus on the land parcel. Here, it's a separate property account with separate property Illinois earnings. We look at actions. The bank account and title are in Wanda's name alone. But then, Hank and Wanda move to California. And the result, the parcel is going to be deemed quasi-community property. Next, we focus on the sculpture. The source was separate property inheritance. The actions include the purchase of the pedestal, the comment about the pedestal, I conclude that the sculpture is going to remain Wanda's separate property. Finally, we focus on what I think is probably the most complicated issue legally and factually: what property is available to pay the child support order and the attorney's fees. Here, for a change, I lead off with the rule. The separate property goes first, community property second. We focus on the actions, and here I organize chronologically based on what happened. The child was conceived several years before this relationship. Hank's liability is established in September of 2000. Hank makes 3 $800 payments, and the couple, Hank and Wanda, separate in January 2002. So we conclude that Hank has sole liability for these payments after the separation. We then focus on the land parcel and the sculpture as potential items that could be available to pay this back child support, and then the attorney's fees we consider last. Fair enough. It's a complicated problem factually, but keeping our wits about us and organizing along intuitively sensible and established lines results in a good setup for a clear, well-organized answer. So now let's briefly have a look at that answer and see if there's any further insights that might be available. First, we focus on the relationship up front. Here, I don't use internal headings, I just explain what happened and indicate we'll have to discuss below in order to reach a conclusion. We consider the fraud, and here I both lead with the facts and interpret them. We focus next on the domicile in Illinois and then the domicile in California. And notice under Section C about the California domicile, I point out that not only is California a community property jurisdiction, it also is a jurisdiction that applies community property laws to non-marital relationships when it deems appropriate. And certainly, this is a situation that cries out for equity, and that's what the California community property laws will provide. So I conclude that Hank won't get away with his fraud, and that we will deem this to be a quasi-community property relationship and act accordingly. So with all that analysis out of the way, now we can consider the actual question presented, which is, what are the spouses or quasi-spouses' respective rights in the land parcel? I focus on the source, and here I lead with the facts. Wanda bought this parcel of land in Illinois with her earnings during the time she lived with Hank. Right after the couple moved to California, earnings of either spouse will be deemed community property. Then we focus on the actions. The bank account and the land title were in Wanda's name alone. And that's great. If we were in Illinois, it would be her separate property. But since we are here in California, we are going to conclude that this is quasi-community property and will apply the California community property laws to this item. So the bottom line, this is a community property item, quasi-community property. Hank and Wanda will be entitled to share its value equally. Title is held by Wanda alone, and the property is outside of California, so we will allow her to keep the property, or at least keep title to it, but Hank will be allowed compensation for his interest. Next, we turn to the sculpture. Here, this is the most straightforward part of the answer, the one that is most common with others that you've seen. The source of this sculpture was inheritance. Inheritance equals separate property. There are a couple of actions. Hank bought a marble pedestal, and that pedestal would be considered a quasi-community property asset. But this pedestal and the statement that they made about, or that Hank made, about it being, quote, our collector's prize, is not going to transmute or change the bottom line, which is this sculpture started out as the separate property of the wife, and at the time that the California courts divide this quasi-marital estate, it will remain her separate property. So now we turn to the child support issues, and we ask and answer the question, what property will be available to pay them? And we start off by leading with the facts. The paternity suit was filed against Hank in California in March 2000. The child support order was issued, and the attorney's fees remain unpaid. Here, I actually have a section entitled Rule. I don't think there are any other paragraphs in any other of these 100+ answers that you are likely to review where the actual heading reads rule. Okay, well, let's see what it says. In California, where one spouse has a child support obligation from a prior relationship, that spouse's separate property is primarily liable. If necessary, all community property is secondarily liable. And that is a complete and accurate statement of the rule. Now, we focus on the actions. The child was conceived before the relationship between Hank and Wanda. Hank's liability is established in September 2000. He makes 3 monthly payments from his earnings and hasn't paid anything since. Hank and Wanda separate in January 2002, and so roughly $10,000 of past due payments were delinquent at the time the couple separated. That's the amount we're really concerned about. The clear legal conclusion is Hank has sole liability for these payments after the separation. Now, we focus on the $10,000, more or less, that was due and owing before the separation. Now, it's also possible, as I acknowledge in this section of the answer, that the support payments might be made retroactive to the birth of the child. And in any event, it's likely that quasi-community property will be attached to support this debt if he doesn't have enough separate property to do so. So we focus on the land parcel and the sculpture. The land parcel is quasi-community property, and if necessary, it'll be liquidated to satisfy the child support debt. The sculpture is Wanda's separate property, and under no circumstances will the separate property of the non-parent spouse, or in this case, quasi-spouse, be attached to pay that back child support. Then look finally at the attorney's fees. Here, I conclude that Hank alone will be liable for the attorney bill, even though this debt was accrued during the time that Hank and Wanda lived together. The case didn't have anything to do with Wanda. Plus, there are no facts in the pattern that suggest the lawyer looked to both spouses for payment. Now, I grant, here there is a fair amount of wiggle room. You could make a reasonable argument that reached the opposite conclusion. But I think you'll probably agree that my answer is the more accurate, the more true answer. And that concludes a discussion of this rather tricky community property fact pattern. It isn't tricky mentally, but it is tricky legally, and it requires some real care to organize carefully and finish on time.